Accordingly, it is the sentence of this court, Anson Bryant, that you serve a period of incarceration in state prison. Court hereby terminates your post-release control, and I am imposing the balance through November 15th of 2020. I believe that comes up to 623 days, according to the DRC's calculation. The court sentences you to prison on count 1, aggravated burglary, felony 1, for 8 years.
Listen to how calmly she's reading this out. 8 years here, 3 years there, but the defendant still hasn't fully processed where this is going.
To a period of incarceration in state prison for 8 years, plus 3 years on the firearm specification. The court sentences you on count 6, weapons under disability, felony 3, for 36 months. And on count 7, CCW, felony 4, for 18 months. The court makes the 2 weapons charges, count 6 and 7, concurrent with each other and concurrent to all of the other charges.
And that word right there, consecutive. That's the word you never want to hear at sentencing. These years are about to start stacking.
And therefore, the order of serving your prison time would be PRC time first, followed by the gun spec on count 1, followed by the gun spec on count 3, followed by count 1, followed by count 2, for a total of 22 years with credit for 231 days.
22 years. At this moment, there is only one smart move. Stay quiet.
Fuck your courtroom, you racist ass bitch! Fuck your courtroom, man! You racist as fuck! You racist as fuck! Nigga, 22 fucking years! You racist ass bitch! You ain't shit! Nigga, gay surgeon, lethal surgeon told me about that bullshit!
Actually, you know what? Remember when I said that you had some remorse?
You never gave me probation!
Wait a minute.
You never gave me a chance!
When I said that you had a certain amount of remorse, I was mistaken. The court determines that maximum imprisonment is needed. So it's 11 years on count 1 and 11 years on count 3.
You racist bitch! You ain't shit!
Manson, calm down, bro.
Let me out the courtroom, man!
Take him out. Hey, just take him out. Just take him out. Get out of
You
here.
racist! That shit bullshit!
Get out.
You racist as fuck!
Hey, take him out, please. Please take him out, please.
I love you, bro.
I love you, man.
I love you, Chad.
So that's 28 years with credit for 231 days.
I don't want to hear it, man! Let me out!
Let's go.
Let me
Hold
out!
on.
22 became 28. 6 additional years after that courtroom explosion. Whatever you think about the sentence, that is a brutal example of how behavior in front of the judge can affect the final moments of sentencing.
Client's presence for the remainder of the advisements I have to give.
Yes, Your Honor.
All right, you can take them.
Jackson, bitch! You are Jackson! Hey, thank you, Dennis!
Thank you, sir.
Court determines that the defendant has shown no remorse whatsoever. I was giving him remorse, a certain amount of remorse in mitigation of the sentence. The defendant has shown me that he has no remorse whatsoever, and therefore the court determines that maximum imprisonment is needed.
And she puts it on the record. In her view, the remorse she thought she saw disappeared.
Versus Gregory Miller. Ms. Bush, do we have any victim impact statement to be made today?
I believe it's attached to the PSI, Your Honor. Other than that, no. Mr. Miller is no stranger to this court. I think the PSI does a good job in laying out a lot of his prior convictions. The biggest thing I noticed in here is, I would say almost all, if not majority of these, he was either on probation, parole, or bond when these occurred. I think that goes to show he is not a good candidate for any type of probation. He has several assaultive priors, including domestic violence as well as just assault and batteries. On top of that, other domestic violences which have been pled down. He's not done well on probation.
This already sounds bad, but listen carefully. The prosecutor hasn't even reached the part that appears to hit the courtroom hardest.
In this case, other than his prior convictions, I would just like to focus the court on the victim impact statement. Although it's short, I think it's very powerful. And I know the police report does describe the injuries that the victim suffered in this case, but in my opinion, it does not do them justice. The photos of the victim's face and injuries are extremely disturbing to look at. For lack of a better term, Mr. Miller did beat the crap out of her. And while I understand that Mr. Miller's underlying issue is clearly his alcohol use, Mr. Miller is very kind and polite when he's sober, but he rarely stays sober. And when he's drunk, he is extremely violent. I think he's been a danger to this community for quite some time.
That contrast is disturbing. Polite when sober, allegedly extremely violent when drunk. And now the court has to decide whether another chance actually protects anyone.
This is a situation that really highlights the issue of substance use disorders. Mr. Miller was homeless at the time, as the prosecution has. When Mr. Miller is sober and away from alcohol, he's a very polite, helpful, and productive citizen of this community. Unfortunately, when you throw in the substance use disorder with homelessness, this is what we end up with.
In no means whatsoever did I intentionally try or mean to harm that woman. She is a fantastic person. She's a great human being and a wonderful woman. I hope she gets the help also that I need, and I'm going to use this time seriously, stay sober and do my best to stay sober.
This is his chance to convince the judge that treatment can change the pattern. But there's a problem. She has his entire history sitting in front of her.
Starts out as a misdemeanor, go by up to 93 days. But I'll tell you, what I'm looking here at is a domestic violence is any assaultive battery. For instance, if I were to push a person, that is domestic violence. If I were to punch a spouse, that would be domestic violence. This damaged her retina, gave her 2 black eyes, bruised a couple of ribs. She had a handprint on her right arm. And I do remember the pictures from this because it was a no contest plea. When it's a no contest plea, I get to look at the entirety of the report. I don't know if the guidelines here are adequate.
And now we reach the number that changes the temperature in this room. This isn't being presented as one isolated incident.
9. You have violated bond, probation, and parole countless times. So,
9. Just let that number sit for a second. Because now you understand why the judge is questioning whether supervision can accomplish anything.
hasn't worked. And at your age, and I'm going to say this, and I don't know how to say it other than just being honest, you have led a life, and this is what I wrote down, a life of boozing and drugs since I was 8 years old. In fact, since you were 9 years old. You and I are roughly the same age. We're only a year and a half apart. So I look at this and I'm just, I hate to say it, but, and here's another thing I wrote down. You are a public drunk, right? Disorderly persons, drinking, drunk all the time in public, and nothing has worked. It's just your criminal history. There are 40 entries. And yes, I know some were dismissed, but 40 entries. You didn't pay for child support. I noticed this one, when you're on probation for failing to pay support, you're arrested on new domestic violence charges. So you drink, you're drunk, and you beat up people. So you got a heck of a benefit.
Bond didn't work. Probation didn't work. Parole didn't work. From the judge's perspective, she's running out of alternatives.
Wow. 14 to 58 months. I could have given you up to 5 years, but they brought it way down. Well, these guidelines are inadequate. I don't have to find substantial and compelling reasons to exceed them. I just have to now by law find that it's reasonable. And your prior history, I can't imagine any human being looking at this prior criminal history and think what my sentence is going to be is unreasonable. It's a life of drinking and beating up people. And I wrote down here, you are a danger to women. And
that may be the most important sentence in this entire hearing. She's no longer talking only about punishment. She's talking about what she believes happens when he gets back out.
Long time. So, well, I'm going to get this $68 state minimum fee, $130 crime victims rate fund fee. I'm going to add $300 court cost, and because I don't know what else to do, I know what my prison term is going to be. I'm going to add $1,000 fine. Some judges will say, why? They're not likely to pay it. Every time I've seen somebody who appeals fines and costs and says it's too much, I haven't seen the appellate courts shoot it down yet. So I'm going to make you have to pay these before you can even get parole. Attorney fee, $300. No supervision fee. There's no DNA fee, nothing like that. And I'm going to sentence you to 36 to 60 months. I find that that's not only proportionate and reasonable.
3 to 5 years. And listen to this. The judge actually says she almost considers that inadequate. That tells you exactly how she views this record.
So that's the sentence of the court. Stop beating up on people. All right, sorry, I take that back. Stop beating up on women. Alcohol daily, marijuana, and methamphetamine weekly. Yeah, let's hope you decide to stop doing it. Let's hope you decide to stop doing it. And you've also have been through domestic violence prevention, substance abuse treatment programs, advanced substance abuse treatment programs, and Catholic Human Services.
2 defendants, 2 very different hearings. But the same lesson hangs over both courtrooms. When a judge believes remorse, supervision, or treatment has failed, every word and every past decision suddenly matters.